Good day, everybody. For decades, medicine moved with one silent belief: doctor knows best. Patients came with pain, fear, and hope. Doctors examined, decided, and treated. Most of the time, this trust between the doctor and patient worked beautifully. But when treatment failed and the matter reached courts, one important question arose, and that is, how should a judge decide whether the doctor was negligent? Welcome to Medico-Legal Dialogues. I am Advocate Sripad, and I have with me Dr. Anil Sangli, Senior Consultant Neuro and Spine Surgeon, and also a lawyer. We are discussing a very important aspect today with respect to medicine and law. Can you just brief the main topic, that is the Bolam test, which we are going to discuss?
Well, most important thing to know initially is medicine is not arithmetic. Two competent doctors may choose two different treatment plans. A complication can occur despite so. So, law needs a fair test as to what should be done, and not to protect carelessness, but to protect responsible medical judgment. This test became important as a Bolam test.
Can you give the historical background of this Bolam test?
It goes way back to 1954. A patient by name John Bolam. He underwent electroconvulsive therapy. Electroconvulsive therapy is a sort of a treatment where an electrical shock is given to the head or the brain of the patient, and then a seizure, that is a convulsion, is induced by an electric shock. And for this, some people use sort of anesthesia so that they will not have very severe problems. And some people use it without giving anesthesia, that is under general anesthesia. So first a general anesthetic was given, and then electroconvulsive therapy was given. A seizure was induced. This was a very famous treatment for depression. This Mr. John Bolam was not warned about the complications of this particular problem. He was given an electroconvulsive therapy, and during that process, he sustained a fracture. So then he went to the court and said, I was not explained about this fracture because of this electroconvulsive therapy. Had I known this, I would not have gone for the therapy at all. And this came to the courts, and it was decided in the United Kingdom in 1957. But even today, that judgment quietly walks into all the Indian courtrooms where a doctor is accused of medical negligence. Because why should an Indian doctor, an Indian patient, and an Indian lawyer, and an Indian judge think or care about a case in English case, that is a Bolam's case? Because this illustrated and elucidated one of the most important principles in medical law, that is the Bolam's principle, and we shall call it as the Bolam fortress.
Today we are not beginning this with fear, but we are beginning with something what we can balance with. To give an illustration, say a patient suffers, family is angry, the doctor says, I followed standard treatment. And the lawyer asks in the court, was it negligence? The court asks, what would a responsible doctor have done? I think this is where Bolam comes in.
Exactly.
Correct?
This is exactly where the Bolam. This is like, it's not a technical or a legal word for lawyers alone. It is for the doctors, for the judiciary, and for the patients also. It is a practical, honest protection for the doctors. Medicine is not always in black and white. It is not mathematics. It's not arithmetic. And there are so many things which can go hayway despite proper medical treatment. So when two competent doctors may choose two different accepted treatments, and a bad result can happen either with either of these treatments, then Bolam test reminds us that both the treatments were correct, both the treatments were accepted medical practice, and so the doctor is not at fault. Complications nevertheless can occur with any form of treatment. This is the basis of Bolam's law.
I can state the legal principle in very simple terms. A doctor is not negligent if he acts according to a practice that has been accepted as proper by a responsible body of medical professionals.
True.
And who are skilled in that particular field.
Yes.
And even if another group of doctors would have chosen some other method, the doctor is protected if his method has some responsible medical support. So Bolam does not ask, according to what you explained, was this the only possible treatment?
Yeah.
It asks, was this an accepted treatment?
True. Whether the treatment is acceptable by a responsible group of medical professionals. This distinction is very important. I'll give another example. Suppose a patient comes with low back pain, he's got a lumbar disc prolapse, and he's got a disc bulge, and he goes to a doctor. The doctor says, we'll go for a conservative management. He goes to another doctor. He says, no, probably you got some weakness. It may progress suddenly. So you go for surgery. That is open surgery. He goes to another doctor, and another doctor says, neither of them, we can go for endoscopic surgery. So these are three different opinions. So the patient is naturally confused. There are three different doctors, three neurosurgeons, three specialists, and all of them giving three different opinions
So
for the
normally-
same problem.
Yeah, normally what a layperson asks is, which treatment is correct, doctor?
Yeah,
and he goes
and-
to each of the doctor and asks which is the correct procedure.
Which doctor is correct and
Okay.
which treatment is correct also.
Hmm.
So the answer may be all the three may be correct, because depending on the patient's condition, most important thing is we should know, examine the patient, see the vitals, see his condition, check his neurology, find out what the MRI findings say, and then go for all these things based on the patient's age, symptoms, his deterioration, his progression, all these things, and then decide on the treatment. So all the three may be correct depending on the situation of the particular patient at that point of time. That is important. So it protects a range of problems which can happen to a particular person.
So you're telling that Bolam is a shield.
It is a shield in a way, yes, but not for everyone. It is a shield where a doctor who acts in good faith and exposes or displays reasonable skill in his treatment and with a recognized medical practice.
So it's not a shield for some casual or reckless treatment.
Yeah, not for casual treatment, not for reckless treatments, or in a treatment, if you're ignoring some danger signs, ignoring the complications, complications can arise. But if you ignore the complication and don't treat that, or don't recognize a complication in time, then it is not a shield for you.
Okay. So from the legal side, I think I can understand why Bolam became important. And it's also true that courts are not hospitals, because when we are dealing in courts with respect to medical aspects, judges do not stand just like a doctor. Their judgments are based on evidence. And they do not see practical aspects what a doctor sees, like the blood pressure falling or the oxygen dropping or the family crying outside.
They are seeing everything after everything is over.
And along with the reports.
Only thing that they can make out and create the situation only by seeing the documents.
So
if you don't have documents, they cannot recreate the situation.
So how do we judge a doctor fairly is the only thing that the law asks.
Yes. So the doctor cannot be judged on like an accountant handling accounts. See, because this clinical medicine always involves uncertainty. And in neurosurgery, for example, I'll give you a patient with a head injury. He may deteriorate despite his treatment. Suppose he comes to the hospital, surgery has been done or surgery may not have been done. He may be treated conservatively, he may be treated with surgery. Suppose he dies with conservative management, or suppose he dies with surgical management. If he dies with conservative management, he will be accused of telling why surgery was not done. If surgery had been done, he would have survived. And if surgery is actually done, they would accuse him why surgery was done. It accentuated the death of the person. He should have been conserved and not operated upon. So either way, there can be an accusation. So the most important thing is, are those two methods, whether it's conservative or whether it is surgery, are these methods accepted methods of treatment? And has due care been exercised in either of them?
I think if every poor outcome becomes negligence, then doctors will not take risky cases at all.
They start practicing defensive medicine, which is very, very risky.
So that's why I think Bolam told courts, do not punish doctors merely because another doctor would have chosen differently. So you have to judge the doctor according to the standard of the ordinary competent doctor in that specialty.
Yes.
True.
Suppose there are multiple doctors and they choose different methods of treatment, and all those methods of treatment are accepted methods of treatment. And if a complication occurs in either of them, any of them, then it is not negligence. It is you cannot hold the doctor responsible. That is Bolam's.
So now coming to the English case of Bolam that has got inserted into Indian law. India follows the common law tradition, and our courts have often relied on English principles where they fit Indian legal conditions. In medical negligence, the Honorable Supreme Court of India used Bolam type reasoning in very, very important cases such as the Achutrao, Haribhau, Khodwa case or the Mathew case. And the idea was very simple. That is, a doctor should not be held negligent if he followed a practice accepted by a responsible body of doctors. And so the patient cannot simply say, treatment failed, therefore negligence.
Yeah, most often they say because there was a complication or the treatment failed, there is a problem that has occurred because of the surgery or the treatment itself. the doctor is negligent. The hospital is negligent. So this concept is not correct.
So I think the
failure of treatment is not negligence.
Yes, I think the patient should show that the doctor's conduct fell below some accepted medical standards,
Yes.
correct? So in many cases, it requires expert medical evidence, and a lawyer must bring medical material to show that the doctor acted outside recognized practice, correct?
Yeah, they have to show that the doctor has done something out of the or deviated out of from the normal accepted medical practice. Suppose I am doing some rare surgery which nobody has done, not described in any textbook, and not peer reviewed by anybody, and it is the first case, and I have a complication. This is a deviation from the normal practice, and a complication has occurred. So that is then you are not shielded by Bolam.
Okay, doctor, I'll ask a simple question which every patient faces or the patient family faces. See, a patient has got a fracture, and one doctor, Mr. A, says, let us operate and fix it with a plate. And Dr. B says, let us use an external fixator. And Dr. C says, in this case, traction and conservative management may work. So the family later says, another doctor would have operated differently, therefore Dr. A is negligent. Is this a correct procedure adopted by the patient? It's not
automatically correct. So, as I told you, it depends upon the circumstance of the case. It depends what type of case it is. Whether A's treatment, Dr. B's treatment, or Dr. C's treatment is an accepted method of treatment. And he performed it with reasonable care. All the three are correct. If reasonable care is not given, there is a breach of duty, and he is negligent in performing or recognizing a complication, then he becomes liable.
So, you are telling that difference of opinion is not the same as negligence?
Yes.
So, I think I should emphasize that once again, difference of opinion is not negligence.
Correct.
And suppose Dr. A did not examine properly, did not take x-rays properly, ignored injuries, for example, like vascular injury or nerve injury, and delayed treatment, and the patient suffered because of that.
Without reason, it becomes negligence and he becomes liable.
So, you are telling that Bolam will not protect in these cases?
See, it's not a proper responsible decision, not properly examined. Patient has not been properly treated according to accepted medical practice. There is a complication because of that. That becomes negligence, doctor is liable.
So, if poor basic care is given, then doctor will be held negligent.
Yeah. I'll give you another neurosurgical example for this. For example, a patient comes to the hospital with a road traffic accident. CT scan shows bleeding. Patient is extremely drowsy and his relatives are crying. One surgeon says surgery. Another surgeon says, no, these things will require ICU monitoring. We'll check it out. And
so, we'll put the patient into the ICU?
ICU. No, both of them will go to ICU. But one will be operated upon by surgery. Another will be observed in the ICU with medical management. So, like how I told you earlier, the patient has a problem and he is operated upon, has a complication. They say, why did you operate? You should have conserved. And suppose he is not operated upon, then he is conserved and the patient dies.
So, it's a double-edged sword.
They'll say, you are conserved, the patient, if you had operated upon him, he would have survived. Like how I gave the same example earlier.
So, in this case, how will Bolam look at this situation?
See, here in Bolam comes in very important because based on the CT scan, based on that particular point of time, the neurological condition, the patient's vitals, his blood pressure, his pupil reaction, his general condition, his Glasgow Coma scale, all these things are important. Suppose the patient who comes in the hospital in the initial stage, he is good, he can be conserved. Over a period of next 6 to 8 hours, he deteriorates. Then it's the time for operating. You cannot keep him conserved. So, recognizing that point of time after 6 hours where he requires surgery and changing over the management style from a conservation to a surgical field, surgical management is important. If that is missed out, then it becomes negligence. Then Bolam won't help you.
So, you are telling that the final outcome alone does not prove negligence?
Yes, final outcome is always either it can be a good outcome or a bad outcome, but whether you have done your duty properly, whether you have not, whether you exercise due diligence, whether a proper care has been given, whether you have followed an accepted medical practice. These are all very important to help you out in the courts where the Bolam test or the Bolam, this actually is a fortress. That's why we call this as a Bolam fortress.
So, legally, if we take up that point, the question is not, did the patient survive? The question that has to be asked in the court is, was the decision reasonable when it was taken by the doctor?
Correct.
So, you're telling that do not judge Monday's emergency with Friday's knowledge. Correct? Okay, doctor. Now let me speak for the patient's family. The patient side may say, this Bolam test is unfair. Doctors support doctors. How will an ordinary patient fight a hospital? And if the medical fraternity closes ranks, where will the patient go? And I think this criticism is real and genuine, and it's happening.
It is real, but we should not avoid this criticism. There can be a reluctance among the doctors to testify against another doctor, but sometimes the family genuinely feels helpless. But the answer is not to punish every doctor with a bad outcome. Bad outcome is not negligence. Bad outcome is not deviation from accepted medical practice. If it is done so, then the answer is to examine the record, see the documentation, see what are all the communications that come through.
I think expert evidence will also help.
Yeah, peer reviews and expert evidence. We should go through that, and then whether the accepted protocols are followed and whether the decisions are made logically. These are very important.
So you're telling that if there is a genuine complication, it should not be considered as negligence.
It cannot be automatically goes as negligence.
Okay, beautiful. So Bolam is necessary, but it must be applied very carefully.
Yes.
So, and I think after this Bolam, two other principles developed, and it has been followed even in the UK and in India. That is the Bolito and Montgomery principles.
Yes. These are very important, very nice principles.
Okay.
The Bolam principle based on the doctor's protection. Bolito is based on the acumen of the judge to give a logical decision. And Montgomery is totally deviated to the patient. We'll come to these things in our future episodes.
Okay, can you just tell me the other side of Bolam? What does Bolam not protect?
See, if a doctor is not protected by Bolam, that means he has not examined the properly. I mean the patient. He has ignored danger signals. He has failed to do basic investigations and management properly. He has not monitored the patients after surgery properly. He has not recognized the complication when it needs to be recognized and acted upon. And he has probably not asked for necessary help, probably when he is not competent enough. These are all the things which are important, where the doctor should be very, very prudent enough.
I'll just intervene. If we read in papers that instead of left side, the patient was operated on the right side, or instead of this patient, especially when there are similarity in the names, the other patient was operated. All this comes under the non-protection under the Bolam.
It does come in the non-protection, but it is not. This comes under res ipsa loquitur. That means the thing speaks for itself.
Okay.
You need not require a judiciary to come and tell the mop was left in the patient's abdomen, so he died.
True.
It is known to even a lay person. This was done. And operating on the right side for a left side injury is again, it's just common sense. So that is res ipsa loquitur.
So you're telling that Bolam is not a hiding place for doctors. And you mentioned the word fortress, Bolam fortress. I think it will be impacting only doctors who are responsible in their medical judgment, and it does not support irresponsibility in medical conduct.
Of course, definitely.
Okay. And doctor, let us clarify some of the words we use in courts: error, complication, negligence. Can you just explain this for the sake of our...
It's very important, because we need to know what exactly we are talking of. First, I'll take what a complication is. Complication is a known risk. It can happen with any medical management or a surgical management. Despite you giving proper care, it can happen. That is a complication. It is a known problem that can happen with a particular procedure or a treatment facility. An error of judgment may happen when a doctor chooses one type of a treatment, reasonable treatment, or another treatment. Suppose I need to continue operating and then finish off this and remove the whole tumor in a brain. That is my judgment. And I will remove the tumor completely, and the scan looks beautiful. The patient has got a paralysis. I will leave a particular tumor there itself, little bit of residue, and the patient wakes up and he walks home, but he still has a tumor. Which error of, is there an error in either these two doctors who completely removed the tumor, who did not remove the tumor? If you completely remove the tumor, you are accused of giving a paralysis. If you don't remove the tumor, they will accuse you of leaving a tumor behind. Both these are correct, depending on the patient's
condition of the-
necessity,
Okay.
patient's requirement, all these things. So
And the condition.
that is the error of judgment if you do it either way, which is wrong. So that particular judgment cannot be held as negligence.
Okay, I think from the legal side, I would like to state a bad result is evidence of suffering, but not automatically evidence of negligence.
True.
And complication must be studied medically, even by the lawyers.
They must know it very clearly, actually better than doctors, so that they can ask questions upon that and then go against a particular treatment facility, which is probably right or wrong.
Okay,
So
and
make the court decide on a proper strategy.
Okay, and the context decides what is an error. That is at the time of the patient's treatment. And negligence must be proved by showing that there is some breach of the accepted standard by doctors. Only then can these survive, I think, isn't it?
That's true. And the best protection from the Bolams comes with proper clinical reasoning, documentation, and not deviating from an accepted practice.
I think I should emphasize that a record is the memory of the hospital, correct?
Yes.
So you have to document each and everything. So would you give any advice for doctors and for patients, doctor?
Well, I'll give a take-home message. For the doctors, Bolam gives protection, but for the doctors, if the practice is responsible, reasonable, proper examination, following of protocols, and take help whenever it is needed, document everything, communicate everything, explain the risks and complications, and don't treat consent and records as paperwork.
Okay, for patients?
And for patients, I would tell them to ask us questions. What they are having, what is the diagnosis, what is the treatment strategy, are there any alternatives for this particular treatment, what can the complications be? And if they don't understand, they can ask again and again until they really understand.
And I think the patient should also maintain the records properly.
Yes, they have to, and follow the instructions properly, because in many follow-ups, we tell them to follow up every week. They come after 3 months. And we tell them to take medicines for a week or 10 days, they take it for 2 months. That's wrong. So they have to follow the instructions exactly. And if they don't follow the instructions, then the doctor is protected.
And I think from the legal point of view, lawyers should not argue only based on emotions. So they have to ask, what is or what was the accepted medical standard? What do the records show? That is the evidence aspect of that. And is expert evidence available? And was a decision taken within a responsible body of medical opinion that forms the basis of the whole cross-examination of...
Here you should have a combination of the lawyers knowing a lot of medical part of their protocols, and doctors should know about law.
Yes,
that combination
that's the
really
convergence.
Helps.
Yes,
that helps a lot.
And I think in the courts, Bolam is a guide to fairness, and we have to respect genuine medical judgment, but we should not allow careless conduct or the carelessness to hide behind expert words.
That's true.
And so today, in this Medico-Legal Dialogues, we opened the Bolam Fortress, which will be continuing for another 1 or 2 series. And to summarize the whole thing, can you just tell us what Bolam states?
We call this as Bolam Fortress because a doctor is not negligent merely because the treatment failed. Doctor is not negligent because another doctor would have acted differently. He is protected when he acts according to a responsible, accepted medical practical principles. But it has got a gate. A fortress always has a gate.
Not only gate, many gates.
Maybe one or many. It protects responsible doctors, not reckless behavior or deviation from accepted practice.
Okay. So I think we can rest at this point. And in the next episode, we will see how this Bolam Fortress has been tested. And the court has been asking, Doctor, your peers may support you, but is the opinion logical? And that is the story of another principle which we'll be dealing later. And we have another one yet lined up. And thank you for watching Medico-Legal Dialogues. And this is where medicine meets law and knowledge protects everyone. So stay healthy, be knowledgeable, and thank you one and all for viewing this session of Medico-Legal Dialogues. Thank you.
Thank you so much.